We're going to conclude this chapter by talking about issues such as dealing with unethical behavior of colleagues, malpractice suits, working inside your scope of practice, stuff like that. Let's start with dealing with unethical behavior of colleagues. It's a difficult discussion. When would a violation of a colleague be serious enough for you to feel obligated to bring it to the attention of an appropriate local, state, or national committee on professional ethics? Ignoring evidence of peer misconduct is an ethical violation in itself. Now, you can handle this in a couple of ways. You can go talk to your colleague informally, confronting them, talk about your concerns, see if there are some resolutions, unless, and this is a big one, unless doing so would violate a client's confidentiality. Be very careful about that. If it falls on deaf ears and nothing changes, you might have to file a formal complaint. Or a formal complaint may need to be filed if the offense is pretty serious, such as sexual exploitation. This chapter goes into detail about malpractice liability, and I think it's a really important section, and you need to understand it fully. So let's define what malpractice is first of all. The failure to render professional services or to exercise the degree of skill that is ordinarily expected of other professionals in a similar situation. Most often, in order to succumb to a malpractice suit, you have to have shown professional negligence. So professional negligence is an unjustified departure from usual practice or from failing to exercise proper care in fulfilling one's responsibilities. It usually results in injury or loss to the client. So keep in mind, this is really important. For a malpractice claim, these four elements must be present. You first of all have to have had a professional relationship between the counselor and the client. You can't be sued for malpractice if it's not your client. The counselor must have acted in a negligent or improper manner or deviated from the standard of care. The third one is the client must have suffered harm or injury. And the fourth one is that there must be legal causal relationship between the counselor's negligence and injury to the client. So in other words, the client has to show that what you did caused them harm, and it was the relationship that client had with you that perpetuated that harm. You must have all four of these elements, and the burden of proof is on the client. Usually, malpractice is limited to 6 kinds of situations. The first one is the procedure is used by the counselor that was not within the realm of accepted professional practice. A while back, there was a lot of talk about regression therapy and a lot of lawsuits. Counselors were practicing regression therapy in order to bring up buried memories. What they found out was that when practitioners used regression therapy, they were suggesting information to the client, who then thought it was a real memory. So that's just one of the situations that could fall into the category of number 1. Counselor used a technique that he or she was not trained in. You have to work within your scope of practice. The counselor did not use a procedure that would have been helpful. The counselor failed to warn others about and protect them from a violent client. We're going to talk about that also in the next chapter. Get this one, no informed consent was documented. If it's not documented, it didn't happen. Or the counselor did not explain the possible consequences of the treatment. That's why informed consent is so critical in protecting you from malpractice suits. Some of the most common malpractice suits: sexual misconduct, boundary violations, failure to clarify matters pertaining to fees, violating confidentiality, and practicing beyond one's competence. I sat in on a meeting with the ACA board, counseling board, and asked them how they determined if their counselors were working outside their scope of practice. And they told me that, for example, let's just take substance abuse. I said, well, how do you know? There's a lot of clinicians out there that are treating substance abusing clients and have never even had a class on substance abuse. And she said, we really rely on the clinicians to make sure that they're working within their scope of practice. The way we find out about it is if someone files an ethics complaint, we will go to the counselor and ask them to prove to us the training that they've had in those certain areas. So they said, for example, if someone's filed a lawsuit against a client saying they didn't understand addictions and they tried to teach them how to do controlled drinking or whatever, we would ask them to prove to us that they had specialized training in that area. If they didn't, they could lose their license. So that's how that works. Other issues include client abandonment and premature termination. Now, the definition of termination is ethical and clinically appropriate process by which a professional relationship is ended. So if you would terminate a professional relationship and the client is still very vulnerable or maybe suicidal or things like that, you could be held negligent and a lawsuit can be filed. Abandonment. The failure of a counselor to take the clinically indicated and ethical appropriate steps to terminate a professional relationship. Now, some of you may be really worried and say, wow, what if I've got a client that I don't want to work with, I can't work with, can they sue me on abandonment? Well, it's very important that you document a client's termination. Mental health counselors do not abandon their clients. However, the following constitutes abandonment. So look at this carefully. This might make you feel a little better. Abandonment means failing to follow up on outcomes when a client has been hospitalized. So, for example, you've got a client who has a mental breakdown and ends up in the psych hospital. Whoa, I don't want them back. You can't do that. You need to follow up with them once they've left the hospital. Consistently not being able to be reached between appointments. This doesn't mean you have to be on call 24/7, but you have to be available if there's an emergency, or at least have someone who is available to see the client for an emergency. I know some counselors have left messages on their answering machines saying, if this is an emergency, please go to the hospital or dial 911. Continually failing to respond to a request for emergency treatment, or failure to provide for a substitute therapist during vacation times. Those are definitions of abandonment. Now, you need to know that there are some legitimate grounds for you to terminate a client. One of them is no progress is being made. They're not doing the work. They're not doing what they need to do to meet their goals. When they're not cooperating, or when they've abandoned their treatment plan goals and won't stick to what you guys agreed upon. So you can terminate a client and it won't be negligent if it falls under those areas. In order for a client to sue you, they have to show that you've harmed them. Some of these areas may include departing from established therapeutic practices, trying new and weird and crazy things, and it doesn't feel like it's competent or within the clinician's scope of practice. Clinicians must work within their scope of practice, and this goes even to diagnosing a client. You can be sued for misdiagnosis. When you give a diagnosis that you're not qualified to give and it's unfounded, you can be sued for that. As we previously talked about, sometimes those diagnoses are carried throughout the client's life and could affect their ability to get maybe a high security government job or health insurance or life insurance. You have to be really careful about diagnoses and make sure that you understand them and have had the training to back up the diagnosis. Crisis interventions. You must exercise reasonable care, and failure to do so increases the risk of harm to another or leaves the person in worse condition than before the intervention. Watch out for that also. It is never appropriate, let me say this again, it is never appropriate for counselors to engage in sexual contact with clients or become sexually and intimately involved with the client. Never. This really astounds me that I still have clinicians who are taught this over and over again in ethics, and they still have sex with their clients. It's never okay. It doesn't matter if it's consensual. It's never the fault of the client. And not knowing your code of ethics is not an excuse for engaging in a sexual relationship. Initial consent of a client will not be a defense against a malpractice action. Never. So how are we going to protect ourselves? Risk management. The practice of focusing on the identification, evaluation, and treatment of problems that may injure clients, lead to filing of an ethics complaint, or lead to a malpractice action. So here's what you need to do. Identify the potential risk area. Evaluate whether the risk area is serious enough to merit further attention. Employ risk control strategies. And review treatment periodically to ascertain their effectiveness. Now you know the things that you can be sued for. You need to be very careful now to take care of yourself so that you're not negligent, working outside your practice, or harming your clients. If you get sued, or if there's a lawsuit pending, treat it seriously. Don't you try to solve the situation or the matter with your client. You need to get an attorney. Become very familiar with your liability policy. If the client threatens to sue you or you receive a subpoena, contact your insurance company and attorney immediately. You don't need to call them. Never destroy or alter files. That makes you look guilty. Promptly retain an attorney. Prepare summaries of any pertinent events about the case that you can use. And do not discuss the case with anyone other than your attorney. Determine the nature of support from any professional association you belong to, and do not continue a professional relationship with the client. Keep in mind that if you stay within your scope of practice, if you know your codes of ethics, if you're not negligent, you will be fine and you will be a good counselor. Stay on top of the different laws and changes and keep up on areas where you may need to work to improve your scope of practice. Always document.